Welcome to this explainer. I am absolutely thrilled to have you here today. If you're a focused learner who loves seeing how complex systems develop over time, well, you're in the perfect place. Today, we're going to meticulously unpack the historical, religious, and legal evolution of talaq in India. We are going to stick strictly to the facts here, drawing directly from historical context, religious doctrines, and major legal milestones to understand exactly how a practice born in antiquity completely transformed under modern constitutional law. Because, this isn't just ancient history. Understanding this evolution is absolutely crucial to grasping one of the most significant constitutional debates of the 21st century. Okay, let's dive into this. This right here is our chronological roadmap for tracing how a unilateral divorce custom evolved step by step into modern law. We'll start with origins and Quranic reforms, look at the three forms of talaq, trace the law under Muslim rulers, examine the Anglo-Mohammedan era, and finally arrive at modern courts and the ban.
Section 1. Origins and Quranic reforms.
To really understand this topic, we've got to rewind the clock and look at the very foundations of Islamic jurisprudence, right back to the time of Prophet Muhammad. And before we even talk about divorce, we need to clarify two frequently confused terms that sit at the very base of our sources. On the left, we have Islam, which translates to submission, and focuses primarily on the spiritual aspect of the faith. But on the right, we have Sharia. Sharia literally means the path leading to the water source. Think about that for a second. In a desert society, water is the most vital resource for survival. So this symbolizes that Sharia is the vital framework for navigating life. It's much broader than personal faith. It encompasses moral, ethical, and highly specific legal rules that dictate commerce, crime, and family life. The Prophet's divine revelations actually transformed existing customary laws into a brand new, comprehensive legal system, linking the spiritual directly with the worldly. So let's define our core subject. Talaq is a unilateral divorce, initiated specifically by the husband under Islamic customary law. It's really important to distinguish this from the other two forms of dissolving a Muslim marriage mentioned in our sources. You've got khula, which is initiated by the wife or by mutual agreement, and that usually involves the wife returning her dower, or mahr, to secure the divorce. And then there's fasq, which is the dissolution of a marriage through a formal court decree. For this explainer, though, we're focusing entirely on talaq. To appreciate the reforms that happened, we have to look at the baseline. In pre-Islamic tribal Arabia, the societal structure was deeply, deeply patriarchal. Men basically held unlimited power regarding marriage and divorce. They could divorce arbitrarily, without any reason, whenever they felt like it. And crucially, because there were literally no limits on how many times a man could pronounce a divorce and then revoke it, women were kept in this endless cycle of rejection. They existed in a permanent legal limbo. They couldn't legally remarry, but they weren't fully treated or protected as wives either. It created a severe gender imbalance with virtually no rights for women. And this brilliantly illustrates how Prophet Muhammad introduced built-in safeguards to fix that. This quote, inspired by Surah 2:228, highlights a massive shift toward reciprocal obligations. Importantly, this introduced the iddah. The iddah is a mandatory waiting period, usually 3 menstrual cycles or 3 months, right after a divorce pronouncement. This wasn't just arbitrary. It was explicitly designed to allow time for the couple to reconsider and reconcile, and practically, to determine if the wife was pregnant. That secured paternity, maintenance, and inheritance rights. It was a huge shift from a tribal system to a family-oriented legal framework. On top of that, the Quran established that talaq could no longer just be an endless game. This verse regulated the revocable nature of divorce to directly counter that legal limbo we were just talking about. It set a rule. After 2 pronouncements of divorce, you have to make a firm decision. Either keep the wife legally and equitably or dismiss her amicably. A 3rd pronouncement, that becomes final and irrevocable. The clear intention here was to put an absolute end to the pre-Islamic practice of endless blackmail and constant rejection. Section 2. The 3 forms of talaq. Now, what's really interesting about this slide is exactly how jurists formalized these categories later on. After the Prophet's death, Islamic jurisprudence kept evolving through different schools of thought. Let's look at the Hanafi school, which is predominantly followed by Sunnis in India. At the top, we have talaq-e-asan, considered the best form. It's pronounced just once during a period of purity, followed by the iddat waiting period. It's the best because it leaves maximum room for reconciliation. Next is talaq-e-hasan, the good form, pronounced over 3 successive periods of purity. And finally, at the bottom, we have talaq-e-bidat, categorized as the sinful form. This is where it's pronounced 3 times instantly, making it immediately irreversible. Let's focus specifically on that last one, talaq-e-bidat, also known as instant talaq or triple talaq. This is the whole crux of our timeline. We've got a fascinating legal paradox here. Classical jurists heavily frowned upon it. They called it an innovation or bidat, making it sinful. Yet, and here is the catch, it was still recognized as legally valid under Hanafi law once spoken. Its mechanics are entirely abrupt. It's executed instantly, in a single sitting, sometimes even via phone, email, or a letter. And crucially, it cannot be repealed once pronounced. We have to understand this abrupt, irreversible nature to grasp exactly what was banned in 2019. Section 3. Laws under Muslim rulers. So we're moving our chronological journey forward now, leaving Arabia and heading into the era of Muslim dynasties in India. Islam arrived in the subcontinent early, around the 8th century, via Arab merchants. By the 16th century, during the Mughal Empire, Emperor Akbar took a very pluralistic, accommodating approach to local customs. Then, in the 17th century, Emperor Aurangzeb finalized the Fatwa-e-Alamgiri. This was a massive undertaking by hundreds of scholars to codify Islamic law for India, cementing Hanafi jurisprudence as the standard for family matters, which was then administered by local judges or qazis. But here's a vital piece of historical context. Why did instant triple talaq become so widely used in India? The sources point straight to cultural syncretism. Historically, traditional Hindu practices in the region didn't recognize structural divorce in the same way. When locals converted to Islam and wanted to divorce, they preferred the fastest, most absolute form of separation to just get definitive closure. Because talaq-e-bidat was so simple and swift, it actually became deeply entrenched into regional Hanafi practice, heavily driven by these local cultural preferences. Section 4. The Anglo-Mohammedan Era. The story shifts dramatically with British colonial rule. So, the crucial point is that the system transformed into Anglo-Mohammedan law. This wasn't pure Islamic law anymore. It was a hybrid. British judges had to administer local family laws, so they'd rely on translated texts or local scholars for advice, but then they'd filter those rules through English common law sensibilities. They were striving for justice and equity, tailored specifically to the colonial framework. The problem was, British judges frankly lacked a deep understanding of the original texts and the actual spirit of Sharia. Because they couldn't read the nuances of the original language, they treated moral guidelines as strict, rigid statutory law. So, when a text said instant triple talaq was legally valid, even if it spent pages calling it a sinful innovation, British judges just rigidly enforced its validity. They inadvertently stripped away the religious discouragement and the nuanced safeguards, solidifying a highly mechanical application of arbitrary divorce. That being said, the colonial era did produce some major legislative pushback. Check out the 1939 Dissolution of Muslim Marriage Act. This was a huge milestone. For the first time, it gave Muslim women specific statutory legal grounds to initiate divorce themselves, like if a husband disappeared, failed to provide maintenance, or was cruel. It actually allowed courts to intervene against improper talaq, shifting the balance of marital power for the very first time in centuries. Section 5. Modern Courts and the Ban. Let's move to post-independence India and see how this builds. Decades of judicial interpretation really start to shift here. In 1949, the Mirjan Ali case was still mechanically enforcing talaq, a total colonial hangover. But in 1952, the Narasu Appa Mali case set a precedent that religious personal laws were immune from fundamental rights scrutiny. That's why the practice survived so long. But then, look at the shift. In 2002, the Shamim Ara case saw the Supreme Court ruling that talaq cannot just be arbitrary. And by 2008, the Delhi High Court took a revolutionary step in the Masroor Ahmad case, treating a pronounced triple talaq merely as a single, revocable one. The judicial net was officially tightening. All of this judicial activism finally collided in 2017 with the landmark Shayara Bano case. A 5-judge constitution bench reviewed the practice and officially struck down instant triple talaq. They declared it unconstitutional specifically because it violated Article 14, the fundamental right to equality. Now, it's worth noting this was a 3-2 majority split. The 2 dissenting judges didn't necessarily support the practice, but they legally argued that because it was a matter of personal religious law, only Parliament had the authority to change it, not the courts. And well, that perfectly sets up our final milestone. In 2019, the Indian Parliament answered that call. They passed the Muslim Women Protection of Rights on Marriage Act. This officially banned instant triple talaq, declaring the practice entirely void and illegal. It completely shifted the landscape, making the pronouncement of instant triple talaq a cognizable criminal offense. This legislation represents the culmination of a centuries-long legal evolution, decisively aligning personal religious law with modern constitutional rights. Okay, let's take a breath and summarize the incredible journey we've just been on. Step 1. It started with pre-Islamic unrestricted customs. Step 2. Prophet Muhammad introduces Quranic regulations and vital safeguards. Step 3. Cultural blending under Muslim rulers in India inadvertently entrenches the instant form. Step 4. British colonial rule brings rigid misinterpretation, stripping away nuances. And finally, Step 5. Modern constitutional reform, where the practice is fully banned by Parliament, all tied together into one cohesive narrative arc.
It's literally over a millennium of legal evolution. And I want to leave you, the focused learner, pondering this final provocative question. As personal laws continue to evolve, how do modern legal frameworks perfectly balance ancient religious doctrines with contemporary constitutional rights? It's a hugely complex intersection of history, religion, and modern gender justice that continues to shape our world today. Thank you so much for joining me in this explainer, and I hope this detailed journey has illuminated the fascinating evolution of talaq in India for you. See you next time.